It's late. A knock lands on your front door, not a casual one, 3 sharp raps that you feel through the wood. You look out and see uniforms. A voice says, "Open this door or we'll force it." Your hand moves toward the latch before your brain even catches up. That's not you being weak, that's decades of being told to answer the door when someone official is standing there. But before you turn that handle, give yourself 60 seconds, because whether they can actually force that door comes down to one narrow legal question, and in a lot of these situations, the answer is no, they can't. I'm Adam King. I've spent years breaking down UK law in plain English, and today I want to walk you through exactly what the police need before they can lawfully come through your front door, how you find out in one short sentence without ever opening it, and what happens to them if it turns out they never had the power in the first place. This is general legal information, not legal advice for your specific situation. If something has already happened to you, speak to a solicitor. Let's start with the uncomfortable truth first, because if I only tell you the reassuring half, you're not actually protected. Police can knock on your door at any hour, for any reason, without explaining themselves. That's not a special power, that's something literally anyone can do, your postman included. And yes, sometimes they genuinely can come in whether you like it or not. Nothing I say changes that when it's true. So the real question was never, can they come in? Sometimes they can. The only question that matters at 11 at night is, which situation are you actually standing in? Here's how ordinary, honest people lose this without realizing it. They open the door to show they've got nothing to hide. It feels like the right thing to do. Legally, it's not cooperation, it's permission. And it's permission the police might not have been able to get any other way, because the second you step back and let them through, nobody ever has to answer the harder question, did they actually have the legal power to be there? You've just handed them the same result a power would have given them, for free. Your own decency becomes the opening they didn't have 30 seconds earlier. There are 3 things people instinctively do at that door, and all 3 feel polite, and all 3 quietly cost you something. The first is opening the door itself. Once it's open, anything visible from that doorway, in torchlight, at night, in your hallway, becomes evidence they lawfully obtained. That's not a trick or a technicality. Anything an officer can lawfully see from a place he's lawfully allowed to stand becomes fair game, and your open front door just became that place. The second mistake is one almost nobody warns you about, stepping outside and pulling the door shut behind you because it feels more polite than talking through a gap. Now you're standing outside, in the cold, with 2 officers between you and your own front door. If things escalate from there, you've lost your home as the safest place to be in the worst possible way. The third is arguing. Raising your voice, telling them they have no right, and somewhere in that heated exchange, saying something you didn't need to say, handing them exactly what they didn't walk in with. The fix for all 3 is the same, and it's almost boringly simple. Keep the door shut and keep your voice calm at the same time. Now here's the idea the whole video rests on. Standing at your door and being legally allowed through it are 2 completely different things. Anyone can stand at your door. Coming through it requires an actual legal power, and powers in English and Welsh law aren't vague, they're specific, and they're written down. There's no power called "we're the police." There's no power called "we just need to check something." There's no power called "it'll go easier if you cooperate." There is, however, an actual list, and it lives in one section of one Act of Parliament, Section 17 of the Police and Criminal Evidence Act 1984. It's short enough to read properly. Broadly, it allows a constable to enter and search premises to execute an arrest warrant, to arrest someone for an indictable offence, to arrest for a specific named list of other offences, to recapture someone who's unlawfully at large, or to save life and limb, or to prevent serious damage to property. That's the entire list. 5 doors, and no others exist outside of that, apart from a warrant issued by a court, or you simply agreeing to let them in, which you're always free not to do. The named list in Door 3 is worth pausing on, because it's longer than people expect. It covers things like certain public order offences, some property offences, drink and drug driving offences, animal welfare offences, squatting, breaches of a domestic abuse protection notice, and arrests under the Bail Act. It's not some obscure footnote. But it's still a closed list, which means the same question still applies. Which item on that list are they actually here for? Now here's the part that changes everything, and it sits in the very next part of the same section, and hardly anyone ever gets told about it. For most of those 5 grounds, it isn't enough that something might be going on inside your house. The officer needs reasonable grounds to believe that a specific person they are looking for is on the premises right now. Not someone. Not somebody might be in there. The actual person they came for. We think someone might be inside doesn't meet that bar. We had a report about this address doesn't meet it either. And that matters because that's usually the exact sentence you're likely to hear. There's one genuine exception, and I want to be upfront about it because it's the one that actually gets used most often, saving life and limb or preventing serious damage to property. That ground doesn't require them to be looking for a specific person. If they genuinely believe someone inside is in danger, they can come in and they can force the door to do it, and when that's true, that's the law doing exactly what it's meant to do. It's also why so many doorstep entries get described as a welfare check. Sometimes that's exactly what it is, and that's a good thing. So you don't argue with that ground, you ask about it, calmly, and how you ask decides whether the evening ends in conversation or in a broken door. Which brings us to the sentence itself. Say it calmly, once, through the closed door, and then stop talking, I'm not opening the door. Which power are you using, and who are you looking for? 19 words, and every one of them is doing a job. I'm not opening the door is you declining consent, which you're entitled to do, and which is not obstruction. You're not touching anyone, not blocking anything, just declining to give a permission that was never compulsory in the first place. Which power are you using is really the whole video in 5 words. If a genuine power exists, an officer will name it without hesitation, because officers know their powers. If there isn't one, you've just asked the one question that has no comfortable answer. Who are you looking for? He matters because, outside of a genuine life or limb entry, the law requires them to be seeking a specific person. Asking turns a vague threat into a concrete claim they now have to stand behind. Then you stop talking. No explaining, no filling the silence, no apologizing. The sentence has already done everything it needs to do. And here's the line you must never cross, because this is exactly where people who understand their right still end up arrested. Refusing consent is lawful. Keeping your door shut while you ask your question is lawful. Saying no, you may not come in is lawful. But obstructing an officer who is genuinely acting under a real power is a separate criminal offense entirely. So the moment they actually name a power, a warrant, a named arrest, a genuine welfare concern, your job changes completely. You step back, you don't block, and you let it happen, because you were never going to win this argument on the doorstep. You win it afterwards, in writing, when someone has to put in a document exactly what power they used and what grounds they had for it. That's a fight you can actually win. A few quick things people always ask. If they say they have a warrant, good, because then you're owed something specific. The officer must identify themselves, produce the warrant, and hand you an actual copy of it, not just flash it at the glass. And a warrant only permits a search for the exact purpose it was issued for. Can they turn up in the middle of the night with a warrant? Legally, entry under a warrant should happen at a reasonable hour, unless the officer believes waiting would defeat the purpose of the search, so late-night entry is possible, but it isn't the automatic default. If you live in a flat, the communal front door with the fob isn't the door the law is protecting, your own flat door is. Renting doesn't change any of this either. The legal protection belongs to you as the occupier, not to your landlord, and your landlord cannot hand over permission to enter your home on your behalf. And if they've already come through the door before any of this happened, the moment for arguing is over. What matters now is documenting everything. Names, numbers, which force, the power they named, the exact words used, the time, written down that same night while it's still fresh. Body-worn camera footage of what happened inside your own home is your data, and you're entitled to request it. Let's run it once, start to finish, so you've heard the whole shape of it before you ever need it. 11 at night, 3 hard knocks. You don't open the door. Open this door or we'll force it. You say, calmly, I'm not opening the door. Which power are you using, and who are you looking for? One of two things happens next, and both are better than opening that door blind. Either they name a real power, and you stand back and let it happen, then write everything down the second they leave. Or the tone shifts, softens, backs off, and that shift is your answer, because a power that genuinely exists gets named in about a second and a half. So remember the shape of it. A knock is not a power. Section 17 gives police 5 specific doors, and for 4 of them, they need to be looking for a particular person they believe is inside. Reasonable force is only lawful when an actual power already exists. We'll force it isn't a power, it's a description of what happens if they have one. And the sentence that gets you through all of it, calmly, through a closed door, I'm not opening the door. Which power are you using, and who are you looking for? Know your rights, say less than you think you need to, and keep that door shut until somebody actually names a power. I'm Adam King. See you in the next one.